This is Newsmax TV. I'm Ashley Martella. We're on the phone with Virginia Attorney General Ken Cuccinelli. A federal judge in Richmond ruled Monday that the most controversial provision in the Democrats' health care law violates the Constitution. Mr. Cuccinelli argued successfully that the so-called individual mandate forcing people to buy health insurance and the accompanying penalty are unprecedented, and Congress overstepped its legal bounds in crafting them. The judge ruled the Commerce Clause cannot be used to justify it. First of all, congratulations on your court victory, Mr. Attorney General.
Well, thanks very much. We're obviously happy to win round one.
Virginia is one of the few states in the country with a specific law saying residents cannot be forced to buy health insurance. So while the judge's ruling is huge, might it be seen as a precedent for other states? And does it set a precedent, perhaps?
No question that it can and should be seen as a precedent for other states. The essence of yesterday's ruling focused on the Constitution and the federal statute, not so much on the Virginia statute. The individual mandate, as you said, of the federal statute was found to be unconstitutional. It's too far of a reach for congressional power under the Commerce Clause. The Virginia statute is merely left standing where normally with a constitutional federal law, the Virginia law would fall because they conflict.
Did it surprise you that the judge, Henry Hudson, a George W. Bush appointee, refused to grant an injunction to suspend the law immediately?
No, he had talked about this during the hearing, and what he did do was take the secretary at her word that she said that if he declared the law unconstitutional and some part of it inoperable, that she would honor that declaration, and we obviously expect the federal government to do just that.
But the way HHS Secretary Kathleen Sebelius is talking, it doesn't sound like they're about to give it up.
We'll see how they act going forward. It was not the part of the ruling that addressed the Constitution, and I fully expect virtually every court, because there's so many different alternative remedies you could apply, to have a different one. The one I care most about is the Supreme Court, and the key from yesterday is the constitutional finding. And there were two. You mentioned the individual mandate. The other was the federal government's fallback argument, that is that the penalty for not buying their health insurance was a tax. That's what they argued, because Congress also has the power to tax, so they tried to save the statute that way. And this judge, as three other judges before him, rejected that argument as well.
Some, like your governor, Bob McDonnell, and Virginia Congressman Eric Cantor, both Republicans, want the Supreme Court to rule on this immediately rather than having it go through the usual judicial route. What do you think the next steps will be?
A number of weeks ago, we began talking to the Department of Justice about their willingness to agree to expedite the case because of the incredible uncertainty that not knowing the outcome with respect to this healthcare case has for our whole economy. And we are interested in expediting the case. The Department of Justice hasn't told us whether they are willing to agree to that or not yet, but those are cordial discussions still ongoing, and they have 30 days now 29, to appeal. So that appeal has to be lodged in the Fourth Circuit regardless first, before any motion to expedite could be filed anyway. So we have a little bit of time here before that might happen regardless.
There's also another big Obamacare case pending in Florida. A federal judge in Pensacola is hearing arguments in a challenge brought by officials in 20 states led by Florida. Now, this case challenges the individual mandate and contends the law's expansion of Medicaid to 16 million more Americans places an unfair burden on cash-strapped states. How important will that eventual ruling be in the total scheme of things?
Because of the way the special position of states in our constitutional system, the cases involving the states are the most important cases. So that Florida case is going to be just as important as this Virginia case. And as you mentioned, in addition to the individual mandate which they're attacking, they're also addressing the Medicare Medicaid mandates under a case called South Dakota v. Dole, in which the Supreme Court said, look, even voluntary programs for the states at some point can have so many burdens for the states that they become coercive. And if the Supreme Court finds that the mandates on the states under Medicare and Medicaid in this bill reach that threshold and are coercive, then they may find those parts of the bill unconstitutional, which obviously are the pieces that cost state governments the most money. In Virginia, the cost for the next 10 fiscal years would be $1.5 billion, and that's assuming their cost estimates are right, and they never get those right. They always cost more than they initially estimate.
Mr. Cuccinelli, many say that without the individual mandate, Obamacare could not function. But Howard Dean says the individual mandate is not an essential part of the health care law and was only added to get the insurance companies to sign on. Now, who's right here, and will that be a factor in how aggressive the Democrats are in fighting to keep it intact?
Well, let's look at the federal government's own argument, in which they called it the linchpin of the legislation. That was their word, the linchpin. So obviously they think it's critical, and in their own briefs they admitted that the insurance provisions of the bill cannot survive without the individual mandate because the insurance industry would collapse. This is their financing mechanism.
At first, Obama denied the penalty for noncompliance was a tax. Then, after the Commerce Clause thing didn't work, he did a 180, and he and other Democrats are now saying it is a tax, which would be constitutional, except perhaps not the way the thing was handled. Please sort this out for us.
Well, there's no question that the proponents of the bill argued while the bill was in process in Congress, this is not a tax, this is not a tax. I mean, they were emphatic about it. And then we sued them, of course, on the individual mandate, and they dumped on us for, how awful this case was and how unlikely it was to succeed, and et cetera, until they started reading our arguments. And a few weeks in, they started to realize, oh my gosh, they might win this case. So they started looking for a fallback argument, and the fallback was to argue that the penalty is a tax. And that is not. First of all, the judge noted, as other judges have noted, the flip-flop by both the president and the Congress with respect to that tax argument and discussion. But also, they've also noted that it's fruitless. That no judge in the country has ruled in the federal government's favor on that. In fact, they're 0 for 4, including with Clinton appointees, Bush appointees. You know, everybody likes to focus on who appoints these folks. The federal government has lost every single court case on the tax argument. So that's going nowhere. That doesn't appear to that it'll go anywhere in any court. This whole case is going to come down to the individual mandate and and whether or not that Congress has the power to order us to all buy a product. And realize this isn't just about health insurance and health care. It's about liberty. Because if they can order us to buy health insurance, they can order us to buy cars, they can order us to buy books, they can order us to buy guns or asparagus. There's no limit to how this power could be exercised, and it's critical to the preservation of the Constitution and of liberty that we prevail in this case.
We should note that 2 other federal judges in separate lawsuits in Michigan and Virginia have ruled in Obama's favor on the individual mandate controversy. Now, that's one of the factors cited by those defending the health care law. Do they have a point or not?
Well, certainly the point to draw from that is that there are differences of opinion in how far Congress's power reaches. That's why I believe that this case must ultimately be decided by the Supreme Court. And as I said earlier, the sooner the better. But there is going to be a wide range of decisions in these cases. There are 25 of these cases, last I checked, around the country, 2 of them involving states. And I would note, though, with respect to the states, by the end of January, because of who got elected governor and attorney general around the country in November, by the end of January, over half of the states will be suing as plaintiffs, as parties, their own federal government because of the federal government's violation of the Constitution in ordering Americans to buy these products.
And finally, Mr. Cuccinelli, there's some speculation that you might run for Virginia governor or the U.S. Senate seat up in 2012 held by Democrat Jim Webb. Are you going to run for either or considering doing so?
Well, I have rejected the notion of running for the U.S. Senate in 2012, and 2013 is far enough off that I don't really feel like I need to make a decision on that now. Some people are urging us to run for governor, but we'll put that decision off for a while, and for now we're just going to be the best attorney general I can be and prepare knowing we are going to run in 2013, but the most likely course would be for attorney general.
Certainly you have a lot on your plate. Virginia Attorney General Ken Cuccinelli, thank you so much for talking with us here at Newsmax, and again, congratulations.
Hey, thank you very much. You guys keep up the great work there.
And thank you for watching Newsmax TV.